Hi, good afternoon. My name is Casey Forbes. I'm the Clerk of the Appellate Courts in West Virginia, and I'm here with the committee to revise the rules of civil procedure. We wanted to hold a webinar. Many of you may have already seen some of the presentations given around the state on this topic, the regional bar meetings or at other meetings. We appreciate all of you joining. This is going to be a recorded webinar, which will be posted at a later time to the Supreme Court's, in all likelihood, the Supreme Court's website and YouTube channel. But that'll be announced later exactly where it will be available. This program has been approved for 1 hour of CLE credit. If anyone wants to use the CLE credit, then I'm going to announce the webinar number, the course ID number, and you would have to turn that credit in. The web ID number is 99882. There will be a different course ID number for the pre-recorded video once it's available on the website and the court's YouTube channel. But it has been approved for 1 hour. We're going to begin in just a moment, but just a few other announcements in the beginning. Any questions will have to be typed into the group chat. They have to be provided to everyone, and then we'll be able to see the written questions. We will take questions at the end. Feel free to write them in, but we will actually take questions once the presentation is over. Thank you all again for attending, and our goal today is to provide an overview of the revised rules. We'll give a little bit of a history of how we got to where we are now, and then go through some of the major revisions. This presentation is not meant to touch on every change that was made to these rules, but it will give an overview of how we got to where we are and what some of the significant changes are. So with that, we'll begin. I'm going to give a short overview of the rulemaking process and then the history of how we got to the revised rules in the state they are now. So court rules in West Virginia. In West Virginia, the Supreme Court of Appeals through the West Virginia Constitution has the ability to promulgate rules that have the force and effect of law. There's case law that indicates that if there's a procedural statute and a procedural rule, then the rule trumps. The court takes up rule proposals quite frequently. They have for a long time. Rule proposals are always by administrative order of the Supreme Court, submitted for published for public comment. Those are then the public comments, if they're received, they're considered by the court, and then the court can finally adopt any rule proposals or rule changes. And rules are always adopted or dealt with in other ways that they can be disposed by order, by court order. Those orders are generally available on the Supreme Court's website if you don't know. There's an entire area dedicated to court rules, including court rules orders. The Supreme Court has promulgated more than 24 rule sets in West Virginia. The two major rule sets that bleed into other areas quite frequently are the West Virginia Rules of Civil Procedure, which we're going to talk about today, and the West Virginia Trial Court Rules. The West Virginia Rules of Civil Procedure. They were first adopted in 1959. I believe they were effective in 1960. They were meant to govern the practice and proceedings in most civil litigation throughout the state, not all. There are other areas that have rule sets like habeas and child abuse and neglect. But they, again, the rules of civil procedure also bleed into those areas. Before the rules were promulgated and adopted, courts had to rely on common law, local practice, and there really wasn't a statewide consistency. And so the rules are meant to provide that consistency, reliability, and just general understanding of the process. The rules of civil procedure have been amended many times in their history, 15. The last substantive review and revision was in 1998 before the current revisions. In 2013, the court appointed a 6-member committee to revise the rules or provide a proposal to the court for updates to the rules regarding case law, federal rules, advancements in technology, and other things as well. Those committee members included attorneys that also worked within the court, outside the court, and Professor Charles DeSalvo at the law school, who was the chair of that committee. That committee submitted a proposal to the court in 2014, but the court at that time did not adopt those proposals. Fast forward to 2019, then Chief Justice Beth Walker, pictured here, renewed the Civil Rules Committee. He appointed a committee of 5 attorneys and 1 circuit judge to continue to work with the 2013 committee. And they were meant to do the same thing, consider a variety of factors in considering a proposal to amend the rules of civil procedure. The current committee is composed of 6 members. Judge Reeder, who was the chair of the committee, is now actually a federal magistrate judge, and it's the reason he's not here today. Anthony Magistro, Tom Herney, Zach Ritchie, Amanda Taylor, and Mark Williams, who are all here today. And they're members of the bar who have practiced in this world in the civil litigation for a long time, and have a wide variety of experiences that have came to bear in this committee. So what did the committee consider? So the committee considered each rule in the context of Rule 1, Scope, Purpose, and Construction. They also used the 2014 committee report. They did try to maintain consistency between the state and federal rules, but that didn't always happen. It's not always possible. The state has its own history and traditions built into the rules and practice, and they did maintain aspects of state court practice when it was appropriate. One thing that's important to note that, and I think it helps too to have a then Circuit Judge Reeder on the committee. The court took into account all different constituent groups. So these rules, like I said, have a bearing in many areas of the law, and they tried to take into account different areas that might use the rules. One thing that I thought was fascinating in considering what the committee did and how they did it, all of the committee's recommendations to the court had to be unanimous. They decided that, and they stuck with it. The committee was initially appointed in 2019, and they met for every Tuesday or every other Tuesday for literally years. And in 2021, they submitted their proposals to the Supreme Court. The Supreme Court then considered it internally, and the Supreme Court issued an order to hold an oral argument on these rules, which I went back and did some research, and it's the first time that I could find that the court held a hearing on a rulemaking process. Individuals who submitted comments, this was an extended public comment period. It was a 4-month public comment period. Individuals who submitted comments on certain rules were allowed to come and present their concerns to the court, and the court was allowed to ask questions, and they held an argument just on the proposal. In January of 2024, the court adopted rules as amended from the committee. They didn't adopt all the committee's rules as presented, but they issued an order adopting the rules effective January 1st, 2025. So what did the January order do? It's a 164-page order. It adopted changes to the rules effective January 1st, 2025. It's a strike and insert version that shows the change to each rule. It's available on the court's website. It's also been provided to other areas where people can do legal research, Lexis, Westlaw, etc. Unlike the committee's recommendations to the court, the January 31st, 2024 order actually was not entirely unanimous. There are 2 concurring and dissenting opinions that are appended to the end of that order. So the committee looked at the substance of the process, the practice of civil litigation in West Virginia, but they also looked at the structure. And I think it's important to note that. So in addition to the substance, the court, or the committee and then the court adopted a reorganization of some of the rules for both readability and citation. Just to show a short example, often with especially older case law or older rules, you do see these big block quotes or big block texts that are lengthy. They can be pages long, and there can be a very important provision buried on page 3 in the 18th sentence. And one thing that I think is beneficial to the legal community is that the committee and then the court restructured the rule to allow it to be cited easier, to allow it to be broken up into more manageable bits. In terms of the substance, we're not going to go through every rule today, as I said, but just a few highlights of some of the major changes, some of the significant rules. And so we're going to go through starting with Rule 5.2 and going up to the effective date rule, Rule 86. And with that, I think we'll begin with the substance of the rules. So the first rule to discuss is Rule 5.2, which is a new rule. It has to do with privacy. I say it's a new rule. Actually, portions of it were taken from the Rules of Appellate Procedure, which the Supreme Court's been using for some time. Under Rule 5.2, a party can file confidential documents, and they have to indicate which portion of their filing is confidential. Then the burden shifts to the other side, or other sides, and any party may file a motion to unseal if necessary. There's a response period for the motion to unseal, and that's 10 days. And then any personal identifiers or any time that an individual or something that's confidential is referred to within a pleading, then there has to be a personal identifier or initials so that identity is obscured. Again, that's similar to the practice we use at the Supreme Court and have for some time. And actually, one thing I should have mentioned too, one thing I'll mention now is that the order in January came out with a effective date of January 1st, 2025. And one reason for that is so that we could go around, the committee, the court could educate practitioners on these changes, and also the court system generally, on these changes before they become effective. And so one of the things that came out of the tour that the committee has done to try to educate the legal community and the judiciary is we've gotten feedback on some of the rules and how they would work in practice. And there have been some tweaks, and there may be more. So recently in October, the court issued a few orders tweaking some of the rules of civil procedure as revised. And those are out for public comment. Now, I believe the public comment period has closed. But 5.2 is one of those that needed a tweak. So there are a few changes throughout. There are more. There's more to come on the rule front as well, because we'll get to this at the end. But there are forms as well that are still in the mix that could be that could come out in time for the January 1st effective date, but maybe after. But under Rule 5.2, the change has to do with filing in the e-filing system. And so that's something that if you do want to see what that change would be, again, there is a rules page on the court's website. You can see where it's located. Or you can see the change where it's located within the rule. Okay, moving now to Rule 6.
Good afternoon, everyone. Rule 6 relates to motion practice. And let me say three things about Rule 6. First, under the current rule, if you're trying to calculate the number of days, it matters if it's under 11 and then you don't count weekends and holidays. Rule 6 is consistent with the federal rule. You count every day. So whether it's a Saturday or a Sunday or a holiday, you count all those days. Of course, if the due date lands on a weekend or holiday, you get the next business day or the next non-weekend or holiday to file your paper. So that's one. The second is it establishes a standard briefing schedule. Under the current rule, motions and briefing are filed depending on when the hearing is set. And as a committee, we thought that did two things. One, you could file a motion, and if you couldn't get a hearing date, it would just sit. And the second thing, if someone filed a motion and didn't try to get a hearing date, the circuit judges would have motions sitting around. So under the new rule, if you file a motion, you have 21 days for a response and 7 days for a reply. If you want to notice it for hearing, you've got to give at least 14 days notice. And you would typically think of that, after the time for a reply, but they've got to have 14 days notice of a hearing. This is already being, standard scheduling orders are already being used by the Mass Litigation Panel, the Business Court Division, and a lot of individual circuit judges. So we didn't view this as a huge change, but we think it does give lawyers and the court better control of getting briefing done and getting motions heard. The judges, as in many of the rules, the judges have discretion to set different timeframes or to add timeframes into their Rule 16 orders. So your response is no longer tied to the hearing date. Moving on to Rule 8, this is the pleading standard, and the rule is in language and style very similar to the federal rule. And the reason we want to mention Rule 8 here is there is no change to West Virginia law as it relates to what constitutes an adequate pleading. We remain a fair notice state under Conley versus Gibson. Our courts have never adopted the Iqbal versus Twombly plausibility standard in federal court. I would say the only exception to that you see is in governmental immunity cases where the plaintiff has an elevated pleading standard to demonstrate why immunity doesn't apply on the front end. And so if you want to look at a case, look at Gomez versus ACR Productions in 2019 to give yourself confidence that we didn't adopt the Conley versus Gibson standard. Moving on to Rule 12. Rule 12, again, from a timing standpoint, simplifies things. Right now, your answer is due depending on how your client is served. If an individual is served in person, they've got 20 days. If you have substitute service through the Secretary of State, it's 30 days. All responsive pleadings are due 30 days after service of the summons and complaint. So it's just standardized, and we thought that streamlined litigation. If the court acts on a Rule 12 motion, you move to dismiss and it's denied, you've got 14 days to file your responsive pleading. Note that the motion to strike under Rule 12F is changed from 20 days to 21 days. And I think you'll see this throughout the rule is that things are done in sevens and multiples of 7. So Rule 12 can be adjusted by stipulation and it can be adjusted by an independent court order.
Rule 15 addresses amended and supplemental pleadings. This is another one of these rules, as Casey mentioned earlier, that was restructured for readability, and it also alters the time frame somewhat, but substantively remains the same in terms of the standard, which is the court should freely give leave when justice so requires. That remains the same. So a party may amend its pleading once as a matter of course, that is without a motion, 21 days after serving it. So now there's a time limit. Or if the pleading is one which a responsive pleading is required, 21 days after service of a responsive pleading, or 21 days after service of a motion under Rule 12B, E, or F. whichever is earlier. And a response to an amended pleading is due 14 days after service, which is a change from 10 days in the prior rule. Rule 16 addresses pretrial conferences, scheduling, and management. Importantly here, the committee thought it was important that as we move toward under Rule 26F, obligation for the parties to get together and produce a discovery plan for the court, is also ensure that a timely entry of a scheduling order by the trial court. And here, what the timeframes are: the 90 days after any defendant is served with a complaint, or 60 after that defendant has appeared. And the rule also includes certain categories of required contents of scheduling orders. Much of this will look very much the same to current practice. The overarching purpose, though, of Rule 16 is to ensure that the parties get together, again, under 26F, which one of my colleagues will address shortly, but also to ensure that the circuit court acts in a timely fashion to get the case on a schedule.
Thank you, Zach. And one thing to mention, so I've mentioned earlier that the court did take up some minor changes here and there to the rules of civil procedure, as well as some other rules that have that were impacted by these changes. Rule 16 is one of those. So Rule 16 had a change to the time frames, which is a proposed change. It went out for public comment as well and hasn't been finalized. But the proposed change in timeframes was to change the scheduling order to 120 days after any defendant is served and 90 days after any defendant has appeared. However, that has not been adopted yet, so stay tuned.
Rule 23 on class actions. So essentially, the new rule adopts the procedures for determining and managing class actions that are contained in federal rules of civil procedure. While the procedural rules were intended to mirror the federal rules, the committee intended no substantive change on when class actions get certified and settlements approved, those sorts of things. In case of law, existing case law and practice which should be preserved. Under the new rule, the certification decision happens, quote, at an early practical time after a person sues or is sued as a class representative. That is different from the existing rule, which stated that it would be as soon as practicable. The intent would be consistent with some subsequent case law, that sometimes you need to develop the underlying cases in some manner before you make a decision on class certification. The new rule allows the appointment of interim class counsel in appropriate cases. So you don't have to wait till a class is certified to have somebody appointed to lead the class. And the rule contains detailed procedures on settlements and approval of attorney fees. In addition, when a settlement class happens, if previously the class had been certified as a litigation class and parties had been given the right to opt out, under the old rules, you were stuck if a settlement happened and you were stuck in the class. Now, if a class is certified, goes further through further discovery, and then later settled as a settlement class, you will be given what we call a back end to opt out of the class if you don't like the settlement, or you can object to the settlement. Finally, the rules on side prey distributions have changed. Previously, the rule required that half of any unclaimed funds in a class action would go to legal aid. That was changed under the new rule to reduce the mandatory proceeds to legal aid to 25% and 75% to either legal aid or some other group that benefits from the services of the class.
All right, now let's talk about Rule 26 and how these rule amendments impacted discovery. It's probably one of the more significant ways that these amendments are going to change the practice of civil cases in state court. But if you have had any experience with federal court procedure for early case determinations, mandatory disclosure, and otherwise, these are going to look very familiar to you. First of all, as Zach mentioned when he was talking about Rule 16, when you read Rule 16 and Rule 26 together, just like in the federal rule, there is a provision under Rule 26F that requires the lawyers to get together early in the case to have a discussion about what kind of discovery is necessary and to prepare a proposed discovery plan and a proposed scheduling order. The purpose of having this much activity focusing on what needs to be done in the case early is to hopefully streamline the process of what sort of discovery is going to be necessary, and keeping in mind the fact that there are going to be mandatory disclosures, which we'll talk about here in a minute. So just like in federal court in a civil case, the new Rule 26F in state court is going to require this meeting where you get together and discuss what sort of discovery needs to be made. The other changes that have been made to Rule 26 deal primarily with not only mandatory disclosure, but also the description of how the scope of discovery is to be considered. By and large, there is no change in the scope of discovery based on prior case law. The same sort of rules and cases that existed in regards to the scope of discovery will carry forward. However, there was an elimination of some language that frankly frequently caused some confusion. You're all probably familiar and have heard arguments when there's been a motion to compel, as an example, about whether or not the requested discovery was reasonably likely to lead to the discovery of admissible evidence. The truth is that that language was never intended to define the scope of discovery. It was intended to demonstrate what I think all of us would understand, which is that the scope of discovery is broader than admissibility, and that just because some evidence might be inadmissible at trial does not preclude you from discovering it during the discovery process. But unfortunately, that became confusing, and a lot of lawyers used it to say, well, as long as I can show that it might lead to the discovery of admissible evidence, you should let me have that discovery. In 2014 or 15, I think the federal rules took that language out because of that confusion, and we decided that it would be appropriate to make the same change here. So that language has been taken out. So to the extent that you're dealing after January 1st with issues regarding possible motions to compel, don't use that language because it's now been removed from the rule. The other thing that we changed somewhat in Rule 26, which is different than Federal Rule 26, is the issue regarding proportionality. There has always been a question of proportionality in regards to discovery, but the federal rules made a significant change a few years ago that allowed a party to object to discovery if they believed that it was out of proportion to the needs of the case. We reviewed that, whether or not to make that change, and decided to make a similar but not identical change. And basically, this is how proportionality is going to work in state courts going forward. If you have a case where you believe that the discovery that's been sent to you is out of proportion to the needs of the case, rather than just making an objection, withholding the information that you think is not in proportion, and then forcing the other side to move to compel, instead of that, if you honestly believe that the requested information is not in proportion to the needs of the case, you are now required to file a motion for a protective order. So if you're asserting proportionality as a defense, it is your responsibility to file a motion and tee that issue up, and it will be your burden of proof to show that it is out of proportion to the needs of the case. So that's a slightly different way that proportionality is dealt with in state court versus federal court. The other things that have changed in Rule 26, which are going to be fairly obvious if you've worked in federal court before, is the adoption of the mandatory disclosures under Rule 26A1. Now, that is where you are required to produce the identification of witnesses, identify documents that would pertain to your claims or defenses. And for defendants, it would also require disclosure of certain insurance information. That will be required for civil cases in West Virginia. However, we have built into the new rule some exclusions for mandatory disclosures, some exceptions, one of which is that for cases where the amount in controversy is less than $25,000, but you also need to read the rule because they're enumerated. For instance, condemnation matters are excluded from being covered by this because the procedure for condemnation cases is different. Cases where circuit courts are acting as a court of appeals from an act of another body are also excluded because the acting as a court of appeals in that case, which are very narrow, also doesn't require mandatory disclosures. Keep in mind that there is a provision under the rule that gives the parties by agreement to agree not to have mandatory disclosures. That also exists in the federal rule, and frankly, it just doesn't happen very much because in the 30 years that we've had mandatory disclosures in federal courts, the lawyers have gotten used to it and they find that it's very beneficial in terms of allowing for information to be exchanged early, and it's a very efficient process of exchanging important information. The other mandatory disclosures that exist under the federal rules have been adopted here as well. 26A3, which requires pretrial disclosures 30 days before trial, which is witness lists, trial depots and designations, exhibits, that sort of thing, are required now under the rule. Most scheduling orders had a provision for that, but occasionally there would be a scheduling order that did not provide for pretrial disclosures. Now it's baked into the rule. The other aspect of mandatory disclosure that these rules adopt pertains to experts. And that is the requirement that experts must prepare expert reports if they are retained for that purpose. They have to be signed by the expert. There are mandatory disclosures in terms of information relating to the expert, in terms of testimonial history, compensation, and that sort of thing, the information that they relied on. There is also that provision for non-retained experts that exist. These are all very similar to the federal rules. We also adopted the provision of the federal rules that says that draft reports, since we're requiring reports, draft reports and communications between the expert and counsel regarding those reports is not discoverable because frankly, we understand that in cases where reports are generated, often counsel are involved. They may do an initial draft. Ultimately, the expert has to approve it and sign it, but it eliminates the obvious discovery disputes that could arise because you want to see how often the expert changed the opinions before it became the final opinion. So the same sort of provision that exists in the federal rule now exists in the state rule as well. What we believe by adopting these mandatory disclosures at the beginning of the case through expert discovery and then also pretrial discovery, we think that streamlines the process so that there is no trial by ambush. The parties have a better opportunity early in the case to know exactly what sort of factual issues are going to be considered in this case. And hopefully that will result in a cheaper process for the conducting of discovery.
Okay, Rule 30, dealing with depositions, was modified in a number of ways to make it consistent with the federal rule. Rule 30B6 numbering was restored, which just makes the numbering of the rule consistent with the federal rule for its subparts. And then with respect to Rule 30B6 notices, parties are required before noticing a corporate representative deposition to meet and confer with the other side on the topics in the 30B notice. Depositions are now expressly allowed to be taken by electronic or remote means, and they are limited per deposition to 1 day of 7 hours. The committee did consider adopting the federal rules presumptive limit on the number of depositions you are permitted to take under Rule 30 and declined to adopt that limit. So the number of depositions is not limited by the rule in the new revised state rules like it is in the federal rules. And then Rule 33 limits the number of permissible interrogatories to 25, including subparts. Part of what you just heard Mark discuss from Rule 26 drove that decision because there are mandatory disclosures of certain information. The number of permissible interrogatories was limited to 25 because much of the information that would be sought through those initial interrogatories will already be a mandatory disclosure from the other party. For the same reasons, because there were changes to Rule 26 regarding the scheduling conference and when discovery is permissible, Discovery can no longer be filed with the complaint. It will have to wait the 26F conference between the parties as it does under the federal rule. And then on Rule 34, the rule was updated to reflect electronically stored information and to track the federal rule. The language now indicates that you can request documents or electronically stored information. You can also, in addition to the information, specify the form in which you want the information, although the other party is allowed to object to the form in which you have requested it. The rule permits ESI to be produced in either a form in which it is ordinarily maintained or in a reasonably usable form, all of which is consistent with the Federal Rule of Civil Procedure and modifies the state rules of civil procedure.
Rule 37. Rule 37 deals with compelling discovery and consequences for failing to produce discovery. With respect to the where, the rule makes clear that a motion for an order directed to the parties is made in the court where the action is pending. If it's directed at a non-party, for example, if you are addressing a failure of a witness to appear in deposition in someplace else, that motion shall be made in the circuit court where the discovery is or will be taken. Relating to depositions, the amended rules also address the timing for filing a motion. With respect to depositions, you can either complete the deposition and move for an order, or you can adjourn the deposition immediately and move for an order. That's a change from current practice. The consequences of the motion are also the different standards for that. When a motion is granted, the rule requires that the court shall award costs unless the motion was filed without a good faith attempt to attain the discovery, or the answer, response, or objection was substantially justified, or an award of expenses would be unjust. When the motion is denied, the court may award costs unless the motion was substantially justified or an award of expenses would be unjust. Rule 38 on jury trials. The rule clarifies some issues regarding to jury trial. You're entitled to a jury trial in any issue that's right on any issue trial of right by a jury. The standard for that is still determined by case law in our Constitution. The demand it has to be either included in the pleading or within 14 days after the last pleading directed to the issue. So if you don't include a jury demand in a complaint, and then the defendant answers and you change your mind, you want a jury trial, you have 14 days after that last pleading to add it for a jury trial. The demand is filed in accordance with Rule 5D, which just means you file it for certificate of service. A jury trial is waived unless the demand is properly served and filed, and the demand may only be withdrawn if the parties consent.
All right, let's talk about subpoenas under Rule 45. The amended rule largely tracks the federal rule. There are a couple of important changes to procedure that we need to discuss. One is, if you're moving to quash a subpoena, where should that be? Let's say you have a case in Mason County, but you're subpoenaing documents in Monongalia County, and there's a dispute over the production or compliance with that subpoena. Where should you file your motion to quash? If you're the respondent, if you represent, for instance, the group that is responding to the subpoena. Unlike in the federal rule, which gives you some flexibility, but which is unique to the federal system because there's nationwide subpoena power. What we decided is that it would be appropriate for a subpoena to be adjudicated in the circuit court where the case is pending. So in that example I just gave, if the case is pending in Mason County and the deposition dispute arises in Mon County, you go to Mason County to actually adjudicate that. We also have included in Rule 45 a provision for clawback of electronically stored information. With the last time the rules were adopted, ESI was really not, or amended significantly, ESI was not really a significant issue yet. So we've built into the provisions of several rules, provisions that account for how you deal with electronically stored information. And there's a provision there that if something is inadvertently produced pursuant to a subpoena to allow a clawback. The other issue that often has been litigated, frankly, it's surprising to me, is if a subpoena is issued and then there's an objection that is rendered or filed, but it hasn't been ruled on by the circuit judge, what happens to the process? If you subpoena a witness and ask them to produce documents and it's set for a certain date, and that witness's lawyer files an objection, do you go forward with the deposition or not? And this says that once an objection is actually filed under the rule, you are not required to actually comply with the subpoena until that objection is resolved. We think that makes more sense. It avoids unnecessary arguments among counsel, and it's a provision that largely exists in the federal system as well. Now, Rule 48 deals with juries and polling. We've adopted the provision that says that polling, if requested, should be done by the court, and that there's a provision there that what would happen if some members of the jury show a lack of assent to or a lack of unanimity to the decision of the jury. Under those circumstances, then the judge should take action. So the important thing about this rule is to talk about how polling has to be done if it is requested, but also we've clarified that the parties can stipulate that a jury would consist of any number less than 6. I've never heard of that. I don't think any member of the committee has either. And when we've been around the state talking to different groups, we've asked them if they're familiar with agreements to deliberate with less than 6, and I don't think it happens very often. And obviously, under our provision, the verdict must be unanimous unless there's some provision by statute or unless it's otherwise stipulated.
All right, let's roll on to Rule 50, which is judgment as a matter of law for anybody who's born in 1980 or earlier. It was directed verdict. It's been judgment as a matter of law for a long time. This really is written to match the federal rule. I think a couple of things are important to recognize. One, you get judgment as a matter of law on an issue in the case. It doesn't have to be the entire claim. And so if there's a particular issue that the plaintiff hadn't sustained their burden, or a party has not sustained this burden, you can move for judgment as a matter of law. The court can resolve the issue against the party and grant that judgment. So we believe consistent with current case law as to the standard that a reasonable juror would not have a legally sufficient evidentiary basis to find for the party on a particular issue in question. Rule 53 is a new rule and probably one of the rules that took as much or more time of the committee in discussion as to one, whether to do it, and second, how to do it. Rule 53 now formally ensconces discovery commissioners in the rule. We found that there was a varying, I don't want to say inconsistent, I'd say a varying practice across the state as to whether courts were using discovery commissioners. I think we found by example that a lot of the Kanawha County judges used them, and judges in some of the southern counties and northern counties didn't use them as often. So we had that debate. We had a debate about whether you really ought to be delegating anything to a non-judicial officer. But we ultimately decided that in light of the fact that some judges were doing this, that it required a rule and it required a structure. The first thing is that discovery commissioners, which end up costing the parties money, ought to be appointed in only complex cases. And so if a court decides to appoint or a discovery commissioner, any party has an opportunity to object to that and try to convince the court that the case doesn't merit discovery commissioner or that one shouldn't be appointed. Once a discovery commissioner is appointed, they can hold hearings, make a record, and make recommendations to the circuit court, which the circuit court can adopt or reject. Importantly, as in the federal rules where there is a decision by a magistrate, the parties have the opportunity to object to the findings of the discovery commissioner. Failure to object is a waiver. And then the court is then required to adopt by order the recommendation of the discovery commissioner. And we thought this was really important because it is the order related to discovery that kicks in obligations and the ability to enforce orders under Rule 37. And last, we kind of modeled this after the Nevada rule. And so there's a lot of thinking that went behind this rule.
Okay. Rule 54 is a modification of the state court rule. While the circuit court can still utilize its discretion to certify questions under Rule 54B, the rule was modified. Currently, dismissal of one defendant is a final order under the revised rule. Any decision or order that adjudicates fewer than all of the claims or fewer than all of the parties does not end the action and is not a final order. Rule 56 also had some slight modifications. It clarified that the court may not grant summary judgment without giving notice to the parties. Also permits the court to enter summary judgment for reasons other than those argued by the parties. And then outside of the slide, the rule permits a party to move for summary judgment up to 30 days after the close of discovery. However, that time frame can be modified by the scheduling order, which trumps the standard time frame that would be contained in the rule.
Rule 59 regarding motions for new trials. The takeaway from this amendment is the time change. Anyone who's been through a trial knows that 10 days after a trial flies by. The time period now has changed from 10 days to 28. And it was mentioned earlier, but it's worth mentioning again. A lot of the dates in the revised rules have been changed to be divisible by 7, and this rule is the same. The 28 days for a motion under Rule 59. Finally, Rule 86 has to do with the effective date. So the effective date of these rules is January 1st, 2025. That's when they take effect. This was asked in the live chat, but to answer one question, so the default for rules is that the revised rules trump any pending or newly filed case on January 1st, 2025. However, there is a safety valve provision in Rule 86 that allows a circuit court to determine that using the revised rules is not just or practical. And so, generally speaking, any pending or newly filed case as of January 1st, 2025 will by default use the revised rules, but there is Rule 86. Finally, I mentioned this earlier, but the committee did propose, and the court has before it to consider several forms. Those are still in the process, but there are civil procedure forms, but there isn't an exact timeline of those. But stay tuned. Lastly, read the rules. These rules can be amended and changed. So even the PowerPoint presentation and the presentation given today can be amended. And with that, we're taking questions at the end, and I see some. So what I'm going to do is I'll read the question out, and then the committee can speak to it.
Yeah, I'll do that.
So the first question is, how does the rule permitting depositions by electronic means protect against the dangers of off-camera coaching?
I nominate Mandy Taylor to take that.
I can answer that. So the provision of the rule allowing for electronic depositions does not address that question specifically. However, if you do have concerns about off-camera coaching, A lot of the electronic means for taking depositions permit certain screen setups where all parties can be seen and viewed. I would encourage you to reach an agreement with opposing counsel about how the deposition is set up so that everybody can be viewable on the camera. If you have any concerns about that, I think certainly anybody that intends to conduct themselves in an appropriate manner would have no objection to that. However, if you do have any issues that arise in an electronic deposition, just like any other deposition, Rule 30D permits sanctions for anybody that impedes, delays, or frustrates the fair examination of a deponent. Those sanctions are available against counsel. Those sanctions are also available against deponents. So if there's any misconduct during the course of an electronic deposition, Rule 30D would be the appropriate recourse to seek sanctions for delaying or impeding or frustrating the taking of your deposition.
I'll add that in all of the electronic depositions I've been doing recently since COVID, have been the video recorded. And it's pretty obvious when a witness is looking at somebody else, and it would be easier to prevail, I think, on a motion when you had some video evidence. Another question I've seen asked at the beginning of most depositions is, who is in the room with you right now? And that generally will help you figure out whether it's something you need to worry about.
Yeah, let me also add that in some of the video depositions I've done, the parties have agreed to have the witness in a room by themselves. And that limits the ability to have some sort of foolishness. But I think you still have to ask the witness, do you have any electronic, do you have your phone with you? Is it on? Are you receiving any text? Would you turn it off while the questions are pending? And go through those sort of questions to try to eliminate the possibility that there could be some foolishness that would take place, because we've seen examples from COVID where it's happened. But the rule itself, to answer the question directly, the rule itself doesn't contemplate that, but good procedures and practices by the lawyers hopefully should eliminate the possibility of that sort of problem.
The next question has to do with discovery commissioners and the discovery commissioner rule. The question is, was there consideration of that rule in light of the constitutional provision regarding access to courts?
That's a terrific question, and one of the issues I raised when we discussed this among the committee was whether you could actually do this and charge the parties extra, and I had a concern about that. I think the committee ultimately concluded that creation of the rule was consistent with the court's rulemaking powers under the Constitution. There were already existing rules that allowed for special commissioners in certain cases, and we viewed the appointment of a discovery commissioner as consistent with that existing practice. And by adding the limitation that it should be complex cases only and giving parties the opportunity to object to the appointment of the commissioner, we felt like we came up with a constitutional way to do this. And probably most importantly, the discovery commissioner makes a recommendation. Ultimately, unless the circuit court adopts it, the discovery commissioner recommendation has no effect. And in fact, when this went through notice and comment rulemaking, there was a discovery commissioner who urged the court to adopt a rule that would let the discovery commissioner's orders simply become orders automatically after a certain amount of time. And the committee pushed back on that, saying there needs to be a set process by which the circuit court has to adopt it. So I don't know if anybody has additional comment, but that's a great question, and we did discuss that.
Well, let me also add that to the extent that there's a question regarding access to courts, one of the issues that was mentioned in the comments from some of the parties before the oral argument during the comment period would be, who assumes the cost of that? Because, discovery commissioners are generally entitled to charge for their time. Courts regularly enter orders requiring payment. And there was a question as to whether or not that is appropriate, considering what if you have a pro se litigant? And as is often the case in pro se cases, a dispute regarding discovery? Should that pro se litigant take on that cost? Those are the sorts of things that the judge is going to have the discretion to make a decision about in deciding whether to appoint a discovery commissioner and how they're going to be compensated, if at all. There's no guarantee. I'm sure there are going to be lawyers that would be willing to act as discovery commissioners pro bono. But those are the sorts of questions that need to be directed at the court.
The next question has to do with where the presentation stopped today, whether it stopped at Rule 56, and there were some rules after that. And the question asks about the deadlines for filing a Rule 59A and Rule 59E, or those motions respectively.
Yeah, we did address that in your provision. Then that's where the 28 days comes in. And under 59E, it's also 28 days to amend the judgment.
And then the next question is if a protective order motion is filed regarding a subpoena, the process is suspended until the protective order motion is resolved. What about with respect to other discovery in general? If a protective order is filed regarding overly broad RPD, for example, is the obligation to respond suspended until the motion is resolved?
Well, let me make sure that I understand the question, but if there is a subpoena issue that requires the production of documents and an objection is filed, then compliance with that subpoena, including the document production, is suspended until the objection is resolved. That would not impact other discovery that does not pertain to the subpoena. Is that how you all interpret it?
That's right. I mean, I think the subpoena protection is for third parties.
Yes. And
Well, not necessarily always. I mean, I've seen examples where there's subpoenas directed at a party,
Yeah.
but you're right. It's normally for non-parties.
yeah, I think the question is whether discovery stayed pending a protective order
Generally.
and
No,
that's
it would
no.
not.
The answer to that is no.
But it would apply to whatever discovery is requested pursuant to that subpoena.
Yes. I think there's also a question above that, but maybe we didn't. I can't see that one.
Yeah, the other question is, in a case halfway through discovery, will you need to go back, meet and confer, disclose anything that had not been discovered? No. If you're involved in a case that is currently proceeding under the existing rules, on January 1st, if you have a trial date in March or April, you will be required to do the 26A3 disclosures, which are 30 days before trial. But you do not need to go back and do the 26A1 disclosures because the rule wasn't in effect yet. If you have expert discovery that is ongoing, and we all have cases that are like that, we think that the better procedure now is to have a discussion with your co-counsel or opposing counsel and say, what should we do about this case that's currently pending, that is set for trial next year or more than a year away, so that we can have the best opportunity to comply with the rules that are going to effect in January. And what some of us have done at this table is to agree to adopt the provisions of the rules now, because we think it makes it easier for that transition. But obviously, that's something that has to be done by agreement.
And you could go the other way. You could, if the case was far enough down the line, you could agree that you were going to apply the existing rules. I would recommend that if you reach those agreements, that would be something you should present in the court in a stipulated order and get the court clause in.
Yeah. Now the only
dispute later.
Right.
Yeah, I just throw in, I agree with all that, but nothing about the change on January 1 would affect your obligation under 26E to supplement previously served discovery.
Correct.
Yes.
But you would not have an obligation to go back and do 26A1
Right.
disclosure.
Absolutely.
Right.
These are the
Okay.
best questions yet.
They are good.
Good questions, folks. We
Man.
appreciate that.
Well, those are all the questions we have in the chat, and thank you all for attending. We're right at our mark, 2:30. And this again, the webinar ID for CLE credit is in the chat. This program will be recorded and it will be posted, and that has a separate web course ID for pre-recording CLE credit, and that'll be distributed. That course ID will be available once the recording is posted.
The one final thing I wanted to note is that this group has done a lot of these presentations at the State Bar regional meetings. The slideshow, the actual rules that exist, at least as of now, as Casey said, there's some proposed new changes, and a handy chart on deadlines are posted on the State Bar's webpage. If you go to State Bar's webpage and click on regional meetings, under presentation items, all those materials are there if you want to download those.
Thank you all very much. Thank you, the committee members, and thank you for attending.